do not find by a preponderance of the evidence that acts of unlawful harassment are unlikely to continue. I don't find that that burden has even come close to being met. There is, based on your statements and your characterization of the underlying reasons that this order was issued in the first place, the court does not believe that you have. Mr. Stonecipher is present with counsel Mr. Clark on Zoom, and respondent Ms. Hunt is also present. She is in the courtroom. This is a motion to renew a previously issued anti-harassment order. In this circumstance, the burden is on the respondent to show that further acts of unlawful harassment are not likely to recur, a little bit different than an initial petition. Mr. Clark, why don't you go ahead and present the case on behalf of your client, and then afterwards I'll return to you, Ms. Hunt. You can respond.
Yes, Your Honor. I do agree with your, understanding or your recitation of the law that the burden is on the respondent in this case. There's no, Mr. Stonecipher kind of laid out in the motion, kind of 5 paragraphs that kind of pretty much stated what his concerns were. But the bottom line is there doesn't seem to be really anything that's changed with regard to Mrs. Hunt. I don't believe that, she's ever, acknowledged any kind of responsibility. There is some conduct that's kind of continuing that's maybe not directly relevant to, the statutory requirements for harassment. But she continues to make allegations of child abuse against him, and it's just, I guess for those reasons, really nothing's changed, and he's very concerned that if this is lifted, she's going to continue, there's harassment actions. So that's his position.
Okay. All right. And then just procedurally, the court, I believe Judge Meyer heard a respondent motion to modify the previously issued order, and Judge Meyer denied that after a hearing.
Correct.
Okay. All right. I understand the nature of the petition to extend the provisions of the anti-harassment order for additional time. So looking at the court file, I don't believe I see any written response to that from the respondent. So Ms. Hunt, if you're going to offer any kind of response to that motion, I'm going to swear you in first. Okay.
I was going to ask if we can reschedule it because I didn't have time to get the court all the documents. I have a pretty heavy folder for that. And also I would like to be able to serve the other side so everyone's on the same page, because I address all the concerns that Mr. Stonecipher has in his things, as well as showing a substantial change in evidence, as well as the reasons and motives being different and no longer relevant to the case.
All right, let me ask you a couple questions about that, because as I said, Judge Meyer heard a respondent motion to modify the existing order just a few weeks ago, on December 8th. And I guess it seems unlikely, although I will admit it's possible that there could have been a substantial change of circumstance in those 60 days or so.
Yeah, I'd be happy.
Can you outline that for me?
Yeah. So basically what it was is I wasn't trying to terminate the order or anything. At that point, I was just trying to get permission to talk to the police concerning what my son had said, the allegations. And so the judge let me know that no modification needed to happen in order for that to happen, that I had the permission of the court to do that anyway. So that's why there was no modification.
All right. And then as to the actual issue that's been brought by the petitioner, which is the extension of the existing order.
Mhm.
You were referring to substantial evidence about that, and
Mhm.
I would ask, is that substantial evidence in response to the request to extend the order, or substantial evidence on the issue in general?
It's in response to extending the order and making it permanent. So I have all kinds of counseling records, medical records, the active police investigation. I have taken responsibility for the actions I had taken that had made him uncomfortable. I have entered therapy. I mean, I have all kinds of records to substantiate why there's a change in circumstances and why the original reasons that it was entered are no longer relevant. In fact, our family doesn't feel safe with petitioner anymore because of everything that's gone on in the last 4 months. So my request of the court would be to reschedule so the court has a chance to see all these documents since he's requesting a permanent order, and the petitioner's side has a chance to see all these as well.
Mr. Clark, what do you think about that request?
Well, of course, Mr. Stonecipher would object to that request. If Ms. Hunt had asked additional time to retain counsel, I think that would be a different thing. But this idea that she wants to dump tons of documents and so forth, I mean, this has kind of been her modus operandi, to just go off on tangents, have lots of things that maybe aren't relevant. But I mean, this initial petition for a protection order was granted for a reason. I mean, the court found substantial reasons why this is anti-harassment order found that her conduct met the statute for issuance of an anti-protection order, and we really don't think that anything's changed. That she went to therapy. Well, where's the therapist? Or don't we have a letter from the therapist? I mean, we're going to go down that road. I don't know. I think I guess the court has wants to give due process to the respondent, but then on the other hand, there's just the court's time and petitioner's time to come back again, and his costs and so forth.
Yeah, I understand your position there, Mr. Clark, and those issues that occurred to me when I heard Ms. Hunt say that she was interested in a continuance for that purpose. I'm very aware of the procedural history of this case. I understand the dynamic of the use of litigation as a way to kind of inflict further difficulties and trials on people who are protected by orders. I'm sensitive to the idea of simply just resetting hearings over and over again that cause great harm and consumption of time and resources by the other party. And Ms. Hunt, I'm going to say that I referenced earlier in this hearing that you have had an opportunity to be fully in front of the court 60 days ago on this order. This order has been heard by the court prior to that on more than one occasion. I don't think that you are lacking or have lacked up to now opportunities to address the court with your concerns or to advance your position that there either shouldn't be an order or that the order should be different. And that every time that happens, that brings everybody back to court. That necessitates an appearance that is something that typically is costly in terms of time, money, and resources. And I really am not inclined to set a further hearing unless I'm convinced that there is, one, a productive reason to have that hearing, and two, that it directly addresses your right to be heard by the court on an issue that is in your interest.
Mm-hmm.
And like I said, you've been here recently. These things have been aired out. The status quo in this case is.
You wouldn't let me speak.
Don't interrupt me. Okay, I'm kind of framing it up for you. The status quo in the case is that there is an order in place, that it has been in place for now more than a year, and the presumptions are that it would continue in that fashion, at least for another period of time, maybe not permanently, but for a specified period of time. Not changing anything that is currently, a restriction upon. Now, on the other hand, I do have to recognize there are restrictions upon you, and those can be burdensome. And you have the right to bring those issues before the court for modification if you think it's appropriate, which you have recently done. But I don't want to just reset this to review things that have already been decided by the court, because we won't do that. Or in the alternative, to hear new things that may impact on whether this order should continue. And it's really the limits of that, like new things that the court has not heard before, have not been argued or decided before, that impact whether this order should continue in any form. So does that make sense to you? The universe of things that are part of your concerns about your overall situation are going to have to be narrowed considerably and put before the court in that sort of legal posture that I just described.
Yes, Your Honor.
Okay. So, yeah, all right, Mr. Clark and Mr. Stonecipher, I know that you don't want to do this.
Your Honor,
I'm inclined to some limited relief here to Ms. Hunt, but to substantially narrow the issues.
Right here, the judge reframes the entire battlefield. This is no longer about who feels wronged. It's about who carries the legal burden. In a renewal hearing, the protection order continues unless the respondent proves harassment won't happen again. That presumption changes everything. The petitioner doesn't need to prove fear. The respondent must prove safety. You can feel the pressure shift instantly. This is the kind of procedural moment that quietly determines outcomes before arguments even begin. The stakes are now crystal clear and heavily weighted.
Your Honor?
Mm-hmm.
I think Mr. Stonecipher would be fine if he just gave her this present moment to speak to her.
I would be, absolutely. I'm happy to have her state her concerns. And if I may speak to the allegations.
Yeah,
Mr. Clark and I on January 30th were interviewed willingly by an investigating detective. So I am not averse to her presenting these things in this moment.
All right. So, Ms. Hunt, if you're able to present them now, he is willing to waive prior notice. In other words, that gives you the opportunity to present whatever you want without having to disclose any of it to him first. I put me at a little bit of a disadvantage, but I think I can probably handle it. So if I swear you in, can you present your concerns and any material you have to substantiate those, and we can make a decision today?
I would really like the court to be able to see all the documentation and see if it meets the substantial change and circumstance.
Well, why don't you hand it up to the clerk and let me at least take a quick look at it and see if that's something I can do, right? Kind of on a short timeline like this, or if I think I would.
This is the stuff you sent over the weekend.
The petitioner's side sets the tone with one central message. Nothing has changed. No acceptance of responsibility. No behavioral shift. Continued allegations. Continued concern. Counsel keeps it simple and strategic. This isn't about relitigating the past. It's about risk going forward. If the order is lifted, they argue, the pattern continues. That argument is powerful because it leans on stability and precedent. The court already found harassment once. Why should it believe circumstances are different now? This establishes the uphill climb the respondent is about to face.
Yes.
Is it
we
in
did
here
get
now?
an email- Not yet. I haven't gotten a chance to review it, but
Mhm.
there is stuff that was sent on Sunday,
Hmm.
so I can move that really quick over to the file.
Yeah. Sure.
I also have a copy of that.
Is that an extra copy?
Yeah.
Because if I can see it on paper, that's a little bit easier
Yeah,
too.
perfect.
Yeah, just hand it to the clerk and she'll mark it as having handed to the clerk. Yeah.
I just feel that there's too much there to do it on the spot, so I wanted to give respect to the weightiness of the situation.
All right. Tell you what I'll do. Take a look at this real quick, just the scope, what it all is and how involved it is. Okay, I think I'm ready to proceed with this. Ms. Hunt, I'm going to swear you in and you can add anything in the form of testimony that you think is appropriate. Do you swear that the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth? Okay, go ahead and have a seat there. Now, keep in mind that everything you've handed me has been filed with the court and it's part of the record, so it's not necessary for you to repeat it all. But you can, present your facts and any argument you have to support your response to the motion to extend the anti-harassment. And make sure you talk loud enough so that into the microphone there so that Mr. Clark can hear you.
Okay. All right. It's with a mother's grieving heart that I respectfully submit my request to the courts today that the basis of this order be dismissed due to a substantial change in circumstances and the fact that the reasons and motives underlying in the original protection order are no longer applicable or relevant to the present case. By granting the request, relief for our family would be given for our healing and recovery.
Here's where tension spikes. The respondent asks for a continuance, claiming substantial new evidence, therapy, investigations, documentation. But the judge is clearly cautious. He references procedural history, repeated hearings, and the cost of dragging parties back into court. There's a subtle warning here about litigation being used as pressure. The judge narrows the scope sharply. Only new, legally relevant changes matter. Not broad grievances. Not emotional appeals. This is a courtroom reality check. The message is clear. If you want relief, it must fit the statute precisely.
The substantial change in circumstances are outlined as below. My 7-year-old son's allegations of molestation with 3 people at the preschool between 2022 through 2023, and petitioner being one of the people involved. My son's conversation starting in October of 2025 is documented in the conversations with Nathaniel, and his continuing trying to talk to us is documented in my husband's January 10th document. His current diagnosis of trauma and continued therapy. My child undergoing sexually transmitted disease testing due to his allegations and continuing physical symptoms. My own suffering that I've been diagnosed with PTSD as a response to the emotional and mental anguish of this case, as in exhibit respondents' mental health appointments and clinical notes. An active and ongoing police investigation concerning the allegations stated by my son and petitioner, our own safety concerns because I'm part of the ACP and me and petitioner's information is posted online as in exhibits URLs. The financial burden this has been on our family to keep up with all the aspects of the case, our counseling, medical appointments, and recovery. My own seeking out of advisors for child sexual abuse that have counseled us that our family was groomed.
Now comes the emotional centerpiece. Sworn testimony. Allegations of molestation. PTSD diagnoses. Ongoing police investigation. A grieving mother's tone. She attempts to show transformation. Therapy entered, responsibility accepted, regret expressed. She insists she no longer wants contact. This is a layered defense, emotional, medical, procedural. But underneath it, the court is still measuring one question: will harassment resume? The testimony is intense and detailed, yet the legal standard remains rigid. This is where emotion meets statutory burden, and not always on equal footing.
Due to these reasons, our family no longer feels safe with petitioner. Our son's acting out starting in 2023. Our son's recent and consistent statements concerning petitioner and attempts to talk with us, which we are in full compliance of the police to not talk with him about. Petitioner's probes of the past, when I filed a complaint with the district January 15th, and he filed the anti-harassment order January 22nd of 2025, terminating all probes. A petitioner stated fondness for my son in February of 3rd, 2025, but wanted me not in the picture, which caused my husband to file a no contact letter with the school district, as in exhibit husband no contact letter. So from our perspective, these actions have prevented accountability for the concerns we raised and instead redirected the attention and scrutiny towards our family. Taken all together, these circumstances explain why, in contrast to a desire for being in contact with petitioner, I and my family do not feel safe any longer with petitioner and instead desire no contact. The original reasons and motives for contact were CCing on letters concerning my son's education planning, to have our family concerns addressed, which they were through the district, to show petitioner I was a kind, friendly person that he could have contact with, but I now no longer am seeking that and instead seeking therapy in order to heal and to move on. And I've accepted that petitioner did not want to reconcile and that petitioner is no longer a safe person for our family to do so.
The ruling lands firmly. The judge walks through the statute under RCW 7.105.405 and states plainly that the burden has not been met, not even close. That phrasing is decisive. He says her understanding of the wrongful conduct hasn't changed in a way that reassures the court. That's critical. Courts look for insight and behavioral shift. Without that confidence, the order stands. And not just briefly, it's extended 5 years. This is the moment the case resolves. The presumption held. The protection order survives.
I have taken personal responsibility by both entering therapy along with accepting that it was inappropriate for me to reach out to petitioner through his home by writing a letter of forgiveness and sending gifts there to try and reconcile an issue that happened at the school. I regret any negative emotional or mental impact that my items ended up causing petitioner, and as such, wanting to relieve his distress, I reached out to the district to coordinate the picking up of those gifts. The circumstances surrounding this matter have been a learning experience for me, and I have grown from it, and I will not repeat my mistakes. Over the past 4 months, my actions have not been motivated by any intent to cause petitioner harm or maintain contact. Rather, this period has been focused on ensuring that I act rightly by following the guidance of both counselors and legal counsel, advocating for my autistic son and fully complying with the protection order. I want to ensure that I could report what my son had communicated while also providing him with every available avenue and resource for his healing and recovery. I requested a modification, not a termination, because my concern had to do with the third-party contact part of the clause. Concerning legal fees, petitioner already requested the court award respondent to cover them, but they were denied at the hearing to modify on 12/8. In closing, I do not want, need, or desire any contact with petitioner and simply wish for peace between our two families so we can move forward and heal without the financial burden of a protection order impeding my family's ability to become financially stable and ongoing, and no longer desire to have ongoing legal matters with petitioner. I am fully aware that if Mr. Stonecipher were to feel unsafe and contacted or harassed, that he would have the right to get another protection order, and I accept and heed that warning.
27:34. There's one final layer, attorney's fees. The petitioner seeks them, perhaps as validation. The judge acknowledges the statute allows it but hesitates. He speaks about the chilling effect such awards can have on people genuinely responding to court orders. That's a nuanced judicial balancing act. Ultimately, he denies the fee request. So while the respondent loses the primary fight, she avoids additional financial punishment. The hearing closes professionally, almost quietly. But the outcome is significant: 5 more years under court order, and a clear judicial message about burden and proof.
For the reasons stated in this declaration and its attachments, I respectfully request that this court find a substantial change in circumstances as required by RCW 7.105.500 and not renew the protection order that was set forth to expire on 2/8/26. I have not engaged in and will not engage in any acts of contact or harassment of petitioner. Thank you, Your Honor.
Thank you. Okay. Now, I said at the beginning,
Mhm.
and I'll sort of reframe it, that procedurally, the motion to renew or extend is operating in a set of assumptions that are different from when the case is initially filed. The set of assumptions, so to speak, or presumptions are that the court would extend the order unless the respondent, and that in this case you, Ms. Hunt, carries a certain burden. And so pursuant to that procedure, which is outlined in RCW 7.105.405, the motion has been filed by Mr. Stonecipher to extend. The court has set the hearing. You have responded. The petitioner bears no burden of proving that he's under any current or reasonable fear of harm by the respondent. But the respondent, in this case you, Ms. Hunt, have to show to the court or prove to the court by a preponderance of the evidence that acts of harassment, unlawful harassment, will not occur. That's under subsection 4E of the statute. The respondent has to prove to the court that the respondent will not resume harassment of the petitioner when the order expires. I've listened to your statements regarding that. I've reviewed the court file for the prior procedural history of this case. I've reviewed the documents that you filed in support of your request that the order not be extended. Listen to your testimony and summary as to the reasons that you believe that it should not be. Now, based on those statements that you've made and the evidence that you've submitted, I do not find by a preponderance of the evidence that acts of unlawful harassment are unlikely to continue. I don't find that that burden has even come close to being met. There is, based on your statements and your characterization of the underlying reasons that this order was issued in the first place, the court does not believe that you have changed your approach with regard to Mr. Stonecipher, that your understanding of the, I guess characterizing it as the wrongful conduct that led to the issuance of the order, does not give the court confidence that you will modify your future behavior in the absence of an order by the court that you have no contact with Mr. Stonecipher. Therefore, the court will grant the extension requested by Mr. Stonecipher. The previously issued anti-harassment order will be extended. The court will extend that order on the same terms and conditions under which it currently exists for an additional 5 years.
And Your Honor, will you be ruling on the request for fees, costs and fees?
You did make a request for fees, and I'm going to ask you to stand by on that. All right, I've composed a written order extending the provisions of that anti-harassment order to February 9th of 2031, which is 5 years from today. All right, and Mr. Clark, on the issue of your request for fees and costs. I'm looking in the file and you can point me to it. I don't see it. Any breakdown of the fees and costs to this point.
Yeah, that's correct. I haven't submitted anything at this point. I mean, it's not that much. It's like just for this action itself, it's like $755. I don't know if Mr. Stonecipher is ever going to really bother to try to collect on it, but I suppose as maybe a moral victory.
Well, to be completely upfront with you on that, I know that the statute does provide for the ability of petitioners to get an award of attorney's fees, but I'm really reluctant to do that in this type of case because of the sort of chilling effect that can have on people who are either genuinely bringing or people who are genuinely responding to requests for orders.
Yeah, that makes
there may be
sense.
exceptions to that in cases where people are clearly, acting in an abusive way or in bad faith and attempting to inflict costs on the other side, which, is certainly a different matter.
Understood.
Yeah, I think I'm going to just forego the attorney's fees issue and leave it lie. So at this point, given what I have in front of me here today, I'm going to deny the request for attorney's fees.
Okay. All right. Thank you for addressing it.
All right, Ms. Hunt, I have a copy here of the order that the court just issued extending that anti-harassment order. That's for you.
I make them
Right there. Yeah, on the clerk's bench there. And you are good to go. All right, Mr. Clark, Mr. Stonecipher, thank you.
Thank you, Your Honor.
All right. Bye-bye.